Dear students, GPS CLAT Academy at Gyanodaya, a senior secondary school at Sikar, supports its students in their CLAT preparation. We have started a lecture series which will be delivered to you on a daily basis on YouTube. The lecture series revolves around discussion of mock papers. You can request us for the concerned mock papers. If you intend to join us in our daily discussions, you are most welcome.
So this article is an article which has appeared in the Economic and Political Weekly, has been taken from the Economic and Political Weekly, and since it is concerning a very, very important international development, that is the war between the Hamas and Israel in the Gaza, and there are allegations of genocide in the Gaza. Now, the article highlights that there is a difference between national and international spheres. What is the difference? The difference is that whereas in the national sphere, you have a centralized authority to implement court orders, you don't have a choice of jurisdiction. Whereas in the international sphere, you have a choice of jurisdiction. You may submit yourself to the jurisdiction of the ICJ, or you may refrain from submitting yourself to the ICJ jurisdiction. Why it is so? What is the reason behind it? Can anyone tell me what is the reason behind this kind of disparity between the international and national spheres? Yes, Priyanka, would you want to tell me? What is the difference? What is the reason? Why this kind of disparity? Why in the international sphere you have a choice of jurisdiction? Why, whereas in the national sphere you don't have any choice of jurisdiction, you are bound by the ordinary law courts throughout the length and breadth of the country. What is the reason for this disparity? The reason is not very far to seek, and the reason is that in the international sphere you are dealing with sovereign entities. All countries are considered sovereign, and they are all considered equal. And there is no centralized enforcement mechanism in the international sphere which you see in the national sphere. Therefore, international sphere differs very materially from the national sphere. Having International Court of Justice is not like the Supreme Court of India, which will act when it is approached in appropriate proceedings. This is not the case in international sphere. Whereas in international sphere, the parties approach the International Court of Justice, but before their approach, they should have submitted their instrument of ratification or instrument of adherence to the jurisdiction of the ICJ. This is mandatory. If they don't, then they are not members of the ICJ. They are not member countries. They are not amenable to the jurisdiction of the ICJ. So, what do you have to do to become a member of the ICJ? Further, it is a layered process. Either you join the ICJ by submitting your instrument of ratification, or you become a member to a treaty between the members, between the concerned members, and you become. Here in this case, Israel and South Africa both submitted their consent to the ICJ's jurisdiction, because they are both members of the Genocide Convention, which is an international treaty, and by that way the ICJ could assume jurisdiction over both of them. It was a contentious jurisdiction. This case was not taken up in the advisory jurisdiction of the ICJ. Advisory jurisdiction of the ICJ carries a lot of legal weight. Nevertheless, it is not legally binding. However, the contentious decisions rendered by the ICJ pursuant to its contentious jurisdiction, those decisions are legally binding, right? And what is the meaning of legal binding? The meaning of legal binding is also not the same as is seen in the national sphere, vis-a-vis the international sphere. Now, in the national sphere, once the court passes a decree, it is The next step is the execution of that decree. That decree is enforced by the enforcement mechanism, by the police, by the by following by the police and by the civil authorities, because all the civil authorities have to implement the court orders. They are under an obligation to implement the court orders. But in case of an ICJ judgment, even though it is rendered in the contentious jurisdiction and not in the advisory jurisdiction, the judgment remains enforceable. I mean, the judgment remains binding on the parties, but the enforceability is a problem. Enforceability is a problem because all the member countries, including the parties, conflicting parties, are basically independent and sovereign in their own right, and where you cannot really have a super police system wherein here the police system is there, here the system of civil administration is there, and all those systems are available. But there, these systems are not available. The centralized mechanism of enforcement is not available. But you can say in the person of the Security Council of the United Nations, basically you have a principal organ of the United Nations, which is the Security Council. This becomes enforceable in the Security Council. But then the countries don't go to war based on an ICJ ruling. Instead, they use these rulings in the Security Council as well as outside the Security Council for carrying out their diplomatic way. What is a diplomatic way of settling disputes? I'll give you an illustration of that. For example, there was a recent this conflict which lasted for 4 days between India and Pakistan. So what happened there? The Director General of Military Operations of Pakistan called up the Director General of Military Operations of India and asked for a ceasefire. Right? What is this happening? This is and India launched a diplomatic offensive, and India apprised the world leaders about the kind of transgressions it has suffered and the kind of sort of genocide which was committed on Indians. It was a genocide because you know very well what happened, what transpired. They only singled out the Muslims for this kind, the Hindus for this kind of treatment. Therefore, you can say that elements of genocide were present in the barbaric massacre of Indian nationals which took place in Pahalgam. Tasked to basically go and explain to the world leaders that look, this kind of transgression on Indian soil is not acceptable, and to mobilize the world opinion in favor of India. So these are diplomatic ways in which the pressure is brought about, and sometimes diplomatic pressure is more effective than actual war. For example, India has closed the Indus suspended, put into abeyance the Indus Water Treaty between India and Pakistan. In the long run, you will find that this will exert more pressure on Pakistan than the actual war or the actual hostilities. Though actual hostilities have very tragic consequences, no doubt about it. And today's newspaper says that even Afghanistan is considering putting some kind of water restrictions on the right of flowing water to the Pakistanis. So this kind of thing is that diplomatic pressures, right? These are brought about, and the Security Council mechanism, as I have said, is rather weak in case of international, because countries don't go to war on the basis of a judgment. And the judgment also realizes that in the judgment also the author says that whereas the judgment has weight, diplomatic weight, and it gives an authoritative evidence of the facts that are narrated therein. And nevertheless, the enforcement part becomes a sort of slightly different from the enforcement as we see it in the national sphere, because the international sphere is very different in its operation vis-a-vis the national sphere. There can't be any parallels between the two. The Security Council may mobilize a force and launch an attack on some nation which is committing genocide. But then these kind of decisions are very rare. They don't come about because there are 5 permanent members of the Security Council and there are 10 non-permanent members of the Security Council. So total membership of the Security Council is 15 members. Some permanent member or the other always exercises a veto, and therefore it becomes very, very difficult to initiate action in the collectivity as a Security Council. Those decisions are rather very, very, very difficult. And the whole wisdom of having this kind of you know veto power was that the 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 force of all the big powers should be increased, and they should not be used against each other to undermine the international peace and security, but they should be used with each other, complementing each other to communicate a very powerful deterrence. Now, this powerful deterrence leads to sometimes this kind of arrangement leads to weak enforcement of the and things sometimes events go unpunished. The autocrats who undertake such kind of massacres or genocide, they go unpunished. So these are basically the rest. You have already told me that the genocide convention basically what kind of directions have been passed, interim directions have been passed. The court has the power to pass interim of directions. They have restrained the Israeli army, the Israeli state from committing acts of genocide, and they have also directed them not to release not to obstruct the release of humanitarian assistance. They have even directed them to preserve the proofs if they have any of their acts in their support. So all these things have been narrated, and you also made submissions thereupon. So we have this is what the article talks about, and then let us now take up the questions concerning this article. Question number 108. As you know, we will proceed on an exceptions basis. I repeat this for the benefit of the new student who has joined us. Basically, we will not take up questions which are already marked correct. We may not take them up because it's just a waste of time to discuss something which you already know. We will take up only those which you don't know. So let us see. Country A and B are signatories to the United Nations Charter. That's all right. Being signatories to the United Nations Charter doesn't mean that you are signatory to the ICJ statute also. For that, you have to do the ratification separately, as is specified in the article. Where is it specified in the article? Here it is specified in the article that you have to, how you acquire the jurisdiction. I'll just share this. I don't know why the sharing mechanism has stopped all of a sudden, but I'll share it once again. So I'll share this. Just give me a second, and you'll understand. Yes, jurisdiction. I'll point it out to you. The jurisdiction of the court comprises all cases which the parties refer to it, and all matters specifically provided for in the Charter of the United Nations or in treaties or conventions in force. Therefore, there is a convention, there is a treaty, right? There is a treaty which is there. State party to the present statute may at any time declare that they recognize as compulsory the jurisdiction of the court. So you should also be a party to the statute of the court, to the chief instrument of the court. For that also you should be a party, and that you can become a party when you become party to an international convention like the Genocide Convention, which requires or confers jurisdiction on the ICJ for settlement of disputes referred by the member states. Right. So A and B are signatories to the United Nations Charter. So if A and B are signatories to the United Nations Charter, that of itself does not confer the jurisdiction on the ICJ. Something more is required. They have to, for example, the United Nations founder, the main founder of the United Nations, there are more than 50 founders, around 51 founders of the United Nations Charter, founding members. India was also one amongst them. The United States was the prime mover, but then the United Nations has is not a party to the ICJ statute. They have not joined it. So this is that is the end of the matter. The court doesn't have jurisdiction so far as United Nations Charter is concerned, unless a treaty, specific treaty like Genocide Convention, to which they may be a party, gives that kind of. So they will have jurisdiction limited to that treaty, but not a general jurisdiction covering all matters. If you deposit the instrument of ratification, then probably you'll have a general jurisdiction, whereas in the present case, they will not have a general jurisdiction. Therefore, country A is a signatory to Genocide Convention. Then it becomes the court has a jurisdiction. Country A accuses the military officials of B have carried out targeted elimination of people of the Jewish faith. B denies the allegations. Country A approaches the ICJ for issue of provisional measures against country B. However, country B takes an objection to ICJ's jurisdiction. Now you see, country A decide whether the ICJ may entertain the application. You will see country A is making the accusations, and country A is a signatory to the Genocide Convention. It is not written that country B is also a signatory to the Genocide Convention. The jurisdiction can be assumed only if both are signatories to the UN Charter. It is not written that both are signatories to the ICJ statutes. It is not written. But it is written that country A is a signatory to the Genocide Convention, but the country B is not a signatory to the Genocide Convention. This is not written. Therefore, the ICJ has no jurisdiction. Is that all right? Do you understand what I am saying?
Yes, sir.
Yes, no, indifferent. Say something that you understand, you don't understand. Question.
Yes, sir.
Question. Yes. Question number 109, 100 kids have already responded correct, so I need not look at that. Question number 110. Country C carries out an invasion of country D. Country D requests provisional measures from the ICJ to halt military operations as they have led to mass civilian casualties in country D amounting to genocide. Now, whether mass civilian casualties would amount to genocide or not, that is the question. What is genocide? Let us just see the definition of genocide, what they are saying in genocide definition. Let us just come to that. Following acts shall be punishable as genocide. I'll just share it within a moment. ICC ordered Israel to take these actions. Where is it given? Can you just point out where it is given in the article as to what constitutes the crime of genocide? Yes, it is Article 2nd. I'll just share it. This is Article 2nd, which is talking about genocide means any of the following acts committed with intent to destroy in whole or in part a national, ethnic, racial or religious group. So group-based group killing, whereas when they are having hostilities, then there are killing of members of the group, causing serious bodily harm, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction, imposing measures intended to prevent births within the group, forcibly transferring children to the group to another group. All these actions constitute. If somebody tells me that you kindly summarize this in one line, what will you say? Basically, attempting actions to ensure eradication of a group. And you are talking about group means the group must be based on several considerations, either on nationality, either on ethnic considerations, either on racial considerations, or on religious considerations. So this is so a group which is sought to be eliminated, whatever may be the consideration, whatever may be the common bond between them, nationality or ethnicity or their race or their religion, then that would tantamount to the genocide. That's why I said that since religion was the basis for exterminating of Indians in Pahalgam, so that amounts to, and since the terrorists who basically carried out that act were sponsored by the Pakistani army within Indian territory, therefore we can say that that was an act of genocide. It need not be on a very large scale. It can be on a scale depending on the context also, right? So this is now having established what is genocide. Let us go back to the question as to what it is talking about. Let us just refer back to the question. The question is here. Country C carries out an invasion of country D and then measures to halt military operations. They have led mass civilian casualties. There is no reference to identification of any group based on nationality, ethnicity, race, or religion. Once there is no mention of all that, then in that case this will not come up as a genocide. This will not be. So this is a question testing your understanding of the concept of genocide. All right. Having said that, I'll go to the next question. Once again, 50% of the kids have marked it incorrect, so I'll take it up. The government of country X systematically starves an ethnic group by denying food, water, medical supplies, leading to mass deaths. No direct killings occur. Does this situation qualify as genocide? Of course it does, because it very clearly says starves an ethnic group. Matter comes to an end. If you are starving them, if you are not directly killing them, if you are preventing births in their or if you are disappearing children for that matter of that communities, just like there was done during the Nazi Holocaust. They had carried out all kinds of things unimaginable. So those will all classify for being called as a genocide. Now this is question number 112, which all kids have answered correct. So I need not stay on this. Same for 113, same for 114, same. Then we come to the next passage, which is passage number 20. Now quickly go through it and tell me what is written in the passage. Then I'll summarize the passage. Right?
So, in this article, it is
Yes.
said that the Singapore Supreme Court cancelled an arbitration award,
Yes.
which was written by the former Chief Justice of India, Deepak Mishra, and it was cancelled because it was found that a major part of the award was copied from earlier arbitration cases, and the special purpose vehicle, which was part of the case, pointed out that the Justice Mishra had used material from other similar arbitrations, and instead of writing a fresh award, he used those earlier awards as templates and only made some adjustments to fit this specific case. And Chief Justice Sundesh Menon of the Singapore Supreme Court explained that the SPV had made different arguments in this arbitration compared to the earlier ones, and these new arguments were based on the different facts, such as the amount of delay between certain events, and for example, the delay in this case allowed the SPV to argue on new legal grounds like estoppel, and uh, despite these differences, the award in this case still had at least 212 paragraphs directly reused from the earlier one, which was out of total of 451, and all this raised serious concerns. And the court said that this heavily copy-pasted content that had serious implications. It believed that the independence and fairness which is expected from all three arbitrators in the panel were not maintained, and the other two arbitrators were not involved in this earlier cases from which the content was copied, and they didn't have access to the background materials or arguments that have influenced the award, and this created a major issue because it means that the final decision may have been shaped by the material the other two arbitrators had no knowledge of, and therefore comprising the integrity and fairness of the arbitration process. That's all for myself.
Yes.
So this passage talks about the Singapore Supreme Court quashed an arbitral award led by the ex-CGI Deepak Mishra for citing the extensive copy pasting from the previous ruling, and
Yes.
is also included the MP High Court ex-Chief Justice K.K. Lahoti and the ex-CGI Jammu Kashmir High Court Geeta Mittal were also founded to the compromise the integrity of the arbitration process, and the tribunal copied the 212 out of the 451 paragraph from earlier award. The copied material was extraneous and not raised the parties, and the Singapore Supreme Court ruled this violated the principle of natural justice, where
Yes.
Judge must be impartial, and the parties must be given a chance to defend themselves in
Yes.
the rule of the fair hearing. And
Yes.
every ruling must be explain its reasoning. Decision must
Yes.
have the justification.
Yes.
And this could also involve the contract for the Western dedicated freight corridor, and the Indian government raised the labor wages, leading to the financial dispute. And the matter was referred to the Justice Mishra Arbitration Tribunal,
Yes.
and the court found the award like by the copying the lacking the independent analysis, and the tribunal used to parallel award as a template and without fresh evolution. And the expectation of equality among arbiters was the compromise. And
Yes.
the ruling highlight the concern over judicial integrity in arbitrations, and the set the precedent for international legal for
Yes.
arbitration law.
Yes.
So this article is mostly about how the lack of original reasoning and not adhering to procedural fairness during arbitration can violate natural justice. So, what is natural justice? It is what we call a fundamental principle that judges always follow to ensure fairness and impartiality during any decision making process when they are making a judgment. So the two main principles of this natural justice are rule against bias, so that judges always remain impartial, and a right to fair hearing, so that everyone has the right to be heard before a decision is made against them or regarding them. So the details of this case mentioned in the paragraph are that a arbitration award was delivered by a tribunal led by the former Chief Justice of India, Deepak Mishra. Now, the tribunal involved three people: the former Chief Justice, the former High Court, former High Court Justice K.K. Lathoi, and former Justice Geeta Mittal. Now, the Supreme Court of Singapore had noted that nearly half of the paragraphs that were in the award directly copy pasted from previous two arbitrations involving these same parties, but they were on different issues. Now, the key problem with this copy paste was that while they were involving the same parties, they were not the same issues. They were different issues, and the material that was copy pasted was not shared or debated with the parties that were involved in the current case. Now, this violated the integrity of the arbitration process, as it violated the right to the fair hearing, as the material was not debated with the other party, and therefore it was the failure of the tribunal to draft a independent and issue specific award. So the Singapore Supreme Court had then decided to set aside the award. So such a thing really underscores that original reasoning is something that is imperative while uh, in the process of arbitration, as if we do not discuss the material that is discuss the arbitration process with the other party, then it simply is not fair to the other party and would violate natural justice. That is all from my side, sir.
Yes. So, Vishwasri, beta, would you want to say something? Basically, this is a very piquant situation wherein the former Chief Justice of India um, is caught in a rather very unsavory situation, very uninviable situation, because Justice Deepak Mishra is uh, one of the finest Chief Justices that the Supreme Court has produced, and it is really unfortunate that he landed himself into this kind of controversy. Anyway, we can't. We are not on personalities. We are on the issues that arise out of um, this episode. Basically, this episode will help us to understand as to what comprises of the judicial process, how it works, and what kind of underpinnings it has. It has, first of all, let me clarify, this is an arbitration which is being subject of challenge in the courts. They have, you give the arbitration, and then the arbitration may be the arbitral award given by the tribunal uh, may be subject matter of a challenge in the court on various policies on the ground on very limited grounds, one or two grounds only, that it violates the that the award violates the laws of the country or the applicable laws, that it is perverse and or like this. There are only one or two grounds on which you can challenge an arbitral award. There are many grounds on which you can challenge an arbitral award. Basically, uh, if you have a detailed challenge on the arbitral reasoning, then it would amount to appeal against an arbitral award, and there's no such thing as an appeal. This is just on the basis of largely on the basis of procedural grounds that awards are challenged, and the difference between an arbitration and a court procedure is that in the arbitration you choose your own judges. Arbitration is informal, whereas the law courts are formal. But that does not mean that the arbitral awards are not binding. The arbitral awards are binding as much they are as the court orders and decrees are binding. Court passes a decree in terms of the award, or the parties comply with the award on their own. So that kind of thing takes place. After the award has been given, then the parties may challenge the award on limited grounds. And this is one such ground. On the basis of fairness of procedure, this award has been challenged. So this is about arbitration. Arbitration is a preferred mechanism these days because the courts are having docket explosion, and they have a large number of cases, whereas the number of judicial officers to decide those cases is not that very many. Therefore, you have parallel mechanisms to assist in reducing the docket explosion that has taken place, or flowing of cases on the court's docket. So you have alternative dispute resolution mechanisms such as mediation, conciliation, such as arbitration. And arbitration has become popular. Unfortunately, arbitration has not become popular in our country, partly because it tends to be very expensive. And but arbitration has become very popular in Singapore, and um, um, it still tends to be quite expensive compared to the court proceedings. But it can be quite efficient in the sense that courts take a long time because of the heavy burden of cases. But arbitrators can sit, and if parties cooperate, then they can decide really very fast. So that is the difference between the alternative dispute resolution mechanism, of which arbitration is a part, and the actual legal process, when the procedure is very strict, whereas the arbitration, the procedure is based on respect for principles of natural justice. But the um, actual nitty-gritties of the civil procedure code may not be followed, but the respect for principles of natural justice has to be shown. That is one. That is arbitration. Now, second important thing that arises from this passage is about natural justice. What do you mean by natural justice? Why are you using the word natural before justice? What is natural and what is unnatural about justice? That is the second consideration which arises. Basically, natural justice is a concept which has a moral connotation, right? And natural justice is basically, you can see the natural justice in the um, in the Constitution of India. In Part 3 of the Constitution, you have the underpinnings of natural justice, or the natural law theorists. You can very clearly see those. For example, when I say that Article 14 provides for equality before the law and equal protection of all laws. So what am I talking about? I'm talking about equality, egalitarian principles, equity, inclusion. So I am taking a moral position. Likewise, when I say that everybody shall have the right to life, and state shall not deny anyone the right to life and liberty except according to a procedure established by law. So what am I saying? What am I saying? I am imposing conditions on governance, conditions based on human nature. Therefore, natural law theorists maintain that there are certain universal principles which apply to all the human beings, irrespective of their divisions. And all those human beings, they have a universal appeal. And the reason behind the universal appeal is that the principles are basically in sync, or the principles support the human nature. They are the basis of human nature: equality, transparency, justice, liberty, fraternity. All these are inherent in human beings. And when you are actually implementing all this, then you are basically recognizing the inherent principles in human beings. And that is what the natural theories hold. Natural theories hold that there are universal moral principles, and which universal moral principles can be discovered by application of human reason. And therefore, the natural law theories of human service, you have to see service politics as a service to mankind, and the policy of the state should be directed towards welfare of mankind, welfare of humankind. So that is the underlying moral principle that you can identify in the directive principles of state policy, which is Part 4 of our Constitution. Therefore, natural law theorists, they basically we usually go to the natural law theorists. We start from Socrates, who was there in the long back in the 5th century BC. Then Aristotle, and they talked about natural justice, legal justice. They are different concepts. Natural justice is a higher justice, and legal justice, if it collides with natural justice, that basically crumbles. You can see that kind of philosophy in operation in the Constitution of India, in the Constitution of United States, and all those well-functioning constitutions of various countries, various jurisdictions. You can see that there are a higher set of principles. There are those higher set of principles are enshrined in the Part 3 of our Constitution, which are the directive, which are the fundamental rights, and basically those fundamental rights are used to assess the legal principles, which are the statutes, the laws, the rules, regulations, bylaws, policies, administrative and executive actions, and all these things are basically analyzed on the touchstone of the Constitution, that is the Part 3 of the Constitution. And if they fall foul of the Part 3 of the Constitution, they are struck down. Therefore, natural law, streak of natural law theorization, you can see in the Constitution of India, which basically provides for limited governance, the constitutionalism. And those limited governance is basically based on the principles of natural justice, suggested by the natural law theorists such as Socrates, Aristotle, Stoics, Thomas Aquinas, later on Hugo Grotius. He applied the principles of natural justice to international law. And like this, so coming to the present query before us, basically, what would be the natural justice that we talk about? Basically, the natural justice that we will be talking about, and those principles which ensure fairness, which ensure impartiality, which show transparency in decision making. Those are the principles, and the charge of these principles is electric. so that you can see the judgment of an arbitral judgment of none other than the Chief Justice of the Supreme Court of India has also been struck down. So So the appeal of natural justice, you can see what is the extent of the appeal of principles of natural justice even today. So if you these proceedings, if we identify the principles based on natural law theories as to what are the principles that are applicable here, there will be three principles that will be applicable here. First one is the rule of audi alterum partem, that is the hearing rule. No person should become a judge without no, in any cause without presenting a fair opportunity to the parties. So the fair hearing rule is one that you have to. And what constitutes fair hearing? Fair hearing constitutes you have to give a notice to the person. You have to give the notice to the person of the charges that he has to meet. What is against him? Then on that notice and that those charges, you have to invite a representation from that person. And on the representation, you have to give him a hearing on the representation, the written representation, that is where you have given a hearing or to him. And then you have to pass a reasoned decision. So, and then the judge who sits in this cause, in the case, should also be the one in which he has no interest. He has no interest whatsoever. He should be impartial. So the justice should not only be done, but it should appear to other people also that the justice has been done. That is the high standard of morality that underpins the courts, or for that matter, in this case, the arbitral awards, the arbitral tribunals functioning. The standards are very, very high. So these three rules of procedure ensure that there is fairness, there is impartiality, and there is transparency in decision making. The first one is the hearing rule, that is audi alterum partem. No person should be judged without fair opportunity to present their case. That is number one. They must have a fair opportunity, and fair opportunity, as I have stated, comprises of notice, representation, oral hearing, and reasoned decision. Then bias, that the judge should not have any interest in the subject matter of the dispute, and he should be objective and should maintain distance from the bar, from both the parties, and there should be nothing which shows the bias of the judge. So much so that if one of the parties says that the arbitration was conducted by a judge who had been an advocate of the other party during this thing, so even those awards can be set aside because the judge already was familiar with the case beforehand. Even those can be set aside. Then there should be a reasoned decision, which I already said that is a part of the hearing rule. The reasoned decision should be there. The why reasoned decision? Because reasoned, when you sit down to write, then you have to write in a logically coherent way. And because there is a principle that truth only stands, falsehood falls apart. So you see, that is the importance of reasoned decision. It puts an immediate break on arbitrariness, whimsicality, or irrationality. So reasoned decisions are very important. The process should be open. Open opportunity should be given to the parties concerned. Having said that, now this is the backdrop, the legal backdrop of the article. The rest of the facts have already been stated by you very well. Basically, unfortunately, Justice Deepak Mishra's award got set aside, and based on the principles of natural justice, that the award showed that there are two problems with the award. Number one, that certain paragraphs were lifted from the award in which Justice Deepak Mishra had participated, but those paragraphs basically constituted slightly different fact situations. Therefore, they were not applicable here. Therefore, if you do that, then you have already made up your mind, and you are just looking for reasons. You have not independently applied your mind. You have not independently set forth your reasoning, and therefore the reasoned decision making rule is violated. Then they say that the equality of the arbitral tribunal is also violated, because basically all three should have equal access to the material at hand, and it is stated that some of the judges may not have been the party to the earlier awards, and therefore one of the judges referring to the award, the earlier awards to in writing, which the other judges did not have an opportunity to participate, basically introduces elements alien to the judicial thinking. The once again the reasoned decisions are violated when you are ignorant about an earlier arbitral award which is being used as a template. Then obviously you can't be said to be having applied your mind, your recent decisions. You can't be said to have applied, and this also shows a bias because the subject matter in which the arbitral award is being written, that subject matter is coming from elsewhere, but it is not coming from the facts of the case. Therefore, the rule against bias, that the presiding officer had a bias in the case merely because there were certain other foregoing awards. He did a copy paste job from there. Therefore, the rule against bias is also involved, and fair hearing is also involved because the parties did not have an opportunity to present their case against the new introductions which were being made by the senior judge. So all these principles of natural justice have been held to be violated, and hence the arbitral award has been set aside. Now, having said that, I guess you are with me while I was saying all this. And now let us take up the questions. Incidentally, let me tell you, there is a very interesting rule of procedure in the US courts. You know, they will ensure that the judge is not prejudiced. How they will ensure? We have suppose a bench of 5 judges. 5 judges we have. We don't have this principle, but it is a very salutary principle, and it can really advance the cause of justice if they incorporate this principle. And basically, they have a principle that which judge out of the 5 judge bench is going to write the decision that the Chief Justice decides. So what happens because of that? All the judges are absolutely attentive to what is going on because they don't know who may be called upon to write the judgment. You following? This is very interesting. All the judges are absolutely. Whereas in our case, this is not the case. Now, in such a situation, what is going to happen? One judge who knows that he'll have to write the judgment will be very attentive to the bench. The other one may be sleeping on the bench. You see, that kind of. I'm not saying that this kind of thing is happening, but nothing prevents this kind of thing from happening. There is absolutely nothing in the system, in our system, which can be said to prevent this kind of thing from happening. So that is a very interesting rule. I found the rule very, very interesting, and maybe one day the Chief Justice, our Chief Justice, Honorable Chief Justice, would some Chief Justice at some future time in future might be inclined to implement that might be inclined to incorporate that in the Supreme Court rules, and that may become the fair procedure, part of the fair procedure. But it's really a very interesting procedure to have that kind of procedure. Now, after all, this will promote the cause of law. Having said that, now I will come to question number 115, which is there on your screens. 50% have answered it correct, and 50% incorrect. So I will take it up. Company A and B enter into a commercial. What is this? Yeah, 115 is the one. A and B enter into a commercial arbitration agreement to resolve a contractual dispute regarding payment delays and defective product deliveries. During the arbitration hearing, both parties submit written statement, expert reports, witness testimonies. The sole arbitral tribunal is now satisfied with the materials on record. He consults industry reports and expert opinions. So this is the same thing. He informs the parties about such a consultation. The arbitral award is announced shortly thereafter. Now, none of the parties raises an objection. He says that, look, I'm not very familiar with the system, with the kind of this thing. I have read this book on the subject matter of the award. So the parties say that it's all right. It's all right. No problem, Milord. It's all right. Whatever you are saying, it's okay. The moment you say that, matter comes to an end. Thereafter, you can't say that the judge did not apply his mind to it. Either you say that please don't rely on anything without showing it to us. But then, so I hope the question is clear to you. Now, the second one is answered 100% incorrect. So I'll take it up. A judge in country X is hearing a case between company and company B regarding a financial dispute. Judge holds an insignificant share in A. Share may be insignificant. Share may be of rupee 1, or share may be of even less than that. It may be of some cents. Makes no difference. The moment you have a share, matter comes to an end. You have to recuse yourself from the batch. You have to say that I have a share and I'm not going to participate in this thing. So somebody else has to hear it. So very clear. So which rule of natural justice does it uphold? Bias, financial bias, pecuniary bias. Pecuniary bias can really upset even if it is very small. Suppose it is insignificant, then why do you say that it is a pecuniary bias? Suppose there is only 1 rupee at stake. Then the other principle comes in. Justice should not only be done, but justice should be seen to be done also. The standard is very high. So even if you have a very insignificant petty stake, you cannot continue. Then the fair process will be barred by a bias. In this case, also the bias has been the result, has resulted in undoing of the award. Third question. This also 100% kids have marked incorrect. So I'll take it up. A government department in countrywide terminates an employee based on allegations of misconduct. The employee was a conductor in state railways and state roadways bus, and he was caught red-handed by the flying squad. The accused collected the fare from passengers but did not issue them any receipts. The department reviews the evidence against the employee and issues a termination notice. Baba, what are you doing? If you do that, your termination notice and your termination order will be set aside, because they have not given, not followed natural justice, principles of natural justice. One person must know the case that he has to meet. You have to give a notice, right? And after notice, you have to invite his representation, written representation on the notice. Then you have to give him a fair hearing, oral presentation. Then you have to write a reasoned decision. You have straight away written an order reviewing the evidence at hand. You have not given him an opportunity to rebut the evidence. Therefore, your award is liable to be set aside. You have not followed the fair hearing rule, right? Directed to be reinstalled. This has happened in so many cases. And this fact situation, which is I argued this case in the Supreme Court. This is exactly what happened. The flying squad caught him. He came to me. He said that I don't have the resources. You please fight it out for me in the Supreme Court. The state has gone to the Supreme Court. Then I took his case, and this exactly was the point, and he was reinstated. Right? Then there is question number 118. A national security agency in country Z detains a suspected terrorist without informing them of specific charges or allowing them for a formal hearing. Government argues that disclosing details would compromise ongoing investigations. Now, the fair hearing rule cannot be abused. You can't say that he's a terrorist and he wants a fair hearing. No, that is not possible. Then in that case, you will be given a right to representation. You will be supplied the grounds as is mandated in Article 22 of the Constitution. All that will be done, but then you may not be given full scope. Fair procedure will not be followed. Truncated procedure will be followed because national security consideration is involved. If national security considerations are involved, then the fair hearing rule can be shortened. The process can be abridged to provide a fair hearing, but at the same time provide peace and security to the people. Because people's identities, if they are revealed to the terrorists, they will target them. So that cannot be done. You can't go collecting evidences from the people against a terrorist. You will kill them. So you have to protect them. Therefore, you have to balance. You have to balance the principle of fair hearing against the kind of situation you are put in, right? This question 119 is absolutely correct. 20 is absolutely correct. I need not touch it. 21 is also absolutely correct. Then 20, what is the primary legal flaw with copying substantial provisions of that? We already know there is no independent reasoning. There is respect for prior decision. No, C is the correct answer. We don't need to dwell too much on it. What makes the judiciary the guardian of the constitution? 100% incorrect. It is judicial review. The independence given by judicial review. So A and B are very close choices. Because judicial review gives you independence, but the correct answer will be judicial review. Not only independence, it gives you the power to strike down a law which is infringing the constitution. So that is not merely independence; it is something much more than independence. So that is why, though there is an overlap between A and D, who holds the powers? This is correct. Acting Justice 125 kids have marked it correct. Who has the right to seek advisory opinion? So it is the President under Article 143 of the Constitution. Then you have the power of the Supreme Court of India to decide disputes between central and state falls under its original jurisdiction. So if there is a dispute between the states and on the one side and the union on the other side, or between several states, and the dispute is presented, if somebody asks you what is the correct forum, but then you have marked it correct, why am I wasting my time on this? This is also 100% correct. This one, which one of the following is correct about the Supreme Court regarding its judgment? It can change the judgment. That is the principle of stare decisis, which we have seen in one of the previous articles, or maybe seen very shortly. This thing, it cannot change the judgment. Of course, it can. Then only the Chief Justice can change. No. The bench, there will be a bench of superior number of superior strength, because of the doctrine of precedents, and the doctrine of stare decisis allows to change the judgment. Doctrine of precedent requires a superior numbers. 5-judge bench cannot overrule a judgment given by 7-judge bench. For that, he'll have to constitute a 9-judge bench, and the benches are constituted in odd numbers, so that there is no equality of votes on both sides, and then the matter becomes indecisive. Then I come to salaries of Supreme Court are determined by the Parliament. They are charged on the Consolidated Fund of India for the Supreme Court, and on the Consolidated Fund of the concerned state for the High Courts. Then this is what, which of the following courts in India are known as the courts of record? Courts are records. Court of record is basically a court whose records are enrolled for perpetual memory. For example, you have these digests and these rights, and this, for example, Supreme Court reports are there, EIRs are there, All India reports are there. You have All England reports also. You have Queen's Bench division for United Kingdom. I've seen for the United States, you have something like 2D, 3D, like that. They have their federal 2D, FDR 3D, like that. They have their reports. These are judgments, record of judgments that are kept for perpetual memory. You can have judgments. I have read judgments going so far as the 800th century AD of the United Kingdom courts. So that was at that time, United Kingdom used to be primarily an agrarian society, and those judgments have a very different flavor from today's judgments. They are very interesting to read. But the point is that they are courts of record. That means their judgments are preserved for perpetual memory. They are published law reports that contains their proceedings. Besides, another important feature about contempt, about the court of record, is that they have the power to punish for contempt, right? So these are basically the judgments. These are basically the features of court of records. Now, having said that, let us come to passage number 21. Quickly go through it and tell me what is there in this passage. Or should we take it up tomorrow? Then tomorrow we will have these two legal reasoning and 4 passages of logical reasoning, because we should anyhow finish at least 2 of them. At least one paper in 2 days. If we don't finish one paper in 2 days, then we will be in trouble deep. There's too much to be done, and there will be too little time to do it. So let us be prepared tomorrow mentally that we have to do 6 of them. So we'll go a little fast, and you take a little less time in going through revising in the class. You give a pre-read before the class. That will enable us to move faster, right? Give it up. So let us call it a day, and see you tomorrow on the same mocks paper 66. And go through the legal reasoning. Always follow the set procedure. First legal reasoning, second logical reasoning. The passages which are entitled for legal reasoning, logical reasoning. If there are any other passages that have to be taken up from other sections, like the section on English and language comprehension, I will let you know. Like the section on current affairs, I will let you know. But these are mandatory, legal and logical, because these are highly applied in their nature. And if you remember the basic principles that we are discussing in the class, and as given in the passages which are circulated in the G forms, though, and supplemented by our classroom discussions, that should that should give you a good firepower to have a high score in the exam. So see you, beta. See you tomorrow at the same time.
Dear students, JPS CLAT Academy at Gyanoday, a senior secondary school at Sikar, supports its students in their CLAT preparation. We have started a lecture series which will be delivered to you on a daily basis on YouTube. The lecture series revolves around discussion of mock papers. You can request us for the concerned mock papers. If you intend to join us in our daily discussions, you are most welcome.